Yes, Chair, we can. You can proceed.
We can hear you. My name is Credo. I'm the chairperson of the LPC. I would like to take this opportunity to welcome our Judge President, Poyo Dlwati, and the members of the judiciary who are accompanying her. Unfortunately, I'm unable to see all of them who are present, but I can see Judge Pedersen amongst others, and I can also see who Judge Spear. And also like to welcome members of the LPC, including Pearl and her team, as well as all the legal practitioners who are present today. My task was a simple one, at the request of the JP, to organize all the LP members, all the legal practitioners, that is advocates as well as attorneys, to attend today so that we'll give the JP and her team opportunity to address us on this important occasion, topic of etiquette. JP, I don't want to waste most of your time because we've got an hour that is allocated to this. I'll hand over to you. Thank you very much.
Thank you, Mr. Mlaba, and thank you to you and your team for organizing this session. And I want to extend a warm welcome as well to my colleagues, the members of the KwaZulu Natal Division of the High Court, and all your team, the executive committee of the KZN and those outside, as well as your CEO and her support staff, as well as my team. Good evening, ladies and gentlemen, and my colleagues. I thought, and we, with the support of the judges of the division, we thought it's prudent that we go through some basic things that we ought to address as the division, because things are not going the way they ought to be going. And quite frankly, I wanted my topic to be called Back to Basics. And there's a particular reason for that. It's because we just want everything to go back to where there was walked in. Can you still hear me?
Now we can.
Yes.
Am I audible?
Yes, JP. Yes.
Yes,
Yes,
JP are audible, though there are
Mr.
some
Mlaba,
cuts,
can you hear me? Can somebody confirm that they can hear me?
Yes, I can hear you from the
Yes,
side.
JP, I can hear you.
I confirm we can hear.
Yes, we can hear you, Judge.
Can you now hear me?
We can hear you, JP.
Yes, we can hear.
Yes.
We can hear you, JP.
You're muted for a moment.
Okay, thank you. Yes, Mr. Kabela Mekute, you've got your hand up.
Good afternoon, JP. I can hear you.
Can you now hear me?
We can hear you, JP.
Yes,
Thanks,
JP.
thanks, Rob. Please let me know if there's a problem. I just changed the connection. The other one was not stable.
Cool.
Thank you. I just wanted to, yeah, I think you've heard me. I've welcomed my colleagues on the bench, and I've welcomed the LPC, the Executive Committee, and all the members, as well as the support staff. That is Miss.
JP, you appear to be muted again.
Thank you. I don't know because my hands are far from the laptop. Okay. I'll do as council ought to do. I'll have them on my, maybe it's teaching me as well. I was saying in my introductory remarks that we felt that there is a need for us to just put a few things right, to correct certain practices that we think if left uncorrected, will result in a lot of chaos. I was saying back then, we all know when we walked into the High Court, there was a huge difference. There was order. There was no need for anyone to tell you not to speak loud, particularly in the judges' passages, particularly being on your phone, all sorts of things. But it seems like we are all casual and laid back about it. So the real purpose for today's talk is to just go back to basics. There is nothing big that you are all going to hear. And as we proceed, I've asked my colleagues to add where they would want to add and comment further if they think that I did not emphasize, but please feel free to comment. And for the practitioners, please raise your hand when you're required to speak or to ask any question. I'm going to ask that at 5:15, we stop admitting because the webinar was set for 5 o'clock. So that's one of the things that we really want to put back. So the structure of the talk is we're just going to talk about the court procedures, and thereafter we'll talk about the dress code, and thereafter we will talk about council's behaviors. That is in respect to a double booking and how they address judges. But all of these topics will intertwine because they are all linked. And I don't really want to have too much of borders in between them because I want us to be all free, especially my colleagues, to talk. And maybe as a starting point, I want to say, we are all not going to be rude to counsel or to every other person for you to understand the point we are trying to make. Because some of you want us to really turn the face to be brown or to be red or whatever color before they understand that we are not happy with what is happening, or have a very straight face. Some of us are not like that. So you've got to understand that there's a certain way we do things and there's a certain way we want things done. And we are not taking this from somewhere where it's not legislated or it's not prescribed. Everything that we're going to talk about is something that is prescribed. For instance, on the court procedures, we know that Practice Directive 62, I think, and I think some of the rules, I think Rule 6 refers to it. We know how the papers ought to be prepared. There's a specific font that ought to be followed. It is not allowed for papers to be printed back to back. Only one side of the page must be printed. We're not allowed to quote enormous case law in affidavits. Same with legislation. You just refer to the little bit that you will be talking about. But some want to quote the whole chapter and the entire case on an affidavit, but we know it's not allowed. It's wrong in terms of the rules. Some people do not paginate, index or paginate the papers. That is now the court processes that I want to just focus on. Some people don't paginate. Even when they have paginated, they paginate in pencil, which makes it a bit difficult because in this day and age, you deal with the file, but it goes back to the typist or to the registrar's office. And if a query can come back and you say, but the page number, I've got it in my bench book as page 57. But when you see page 57, it's not like that because somebody might have rubbed off the pencil and put another page. So the index, the pagination, the marking of the papers must really be in a black pen, as we all know. We must index and paginate all papers that come before us. All papers are obviously becoming voluminous every day. We need to know what it is that we're going to hear. If it's an intellectual application, it must be indicated as such so that we don't go through everything else for us to only determine that it is only this part that we ought to talk about. Yes, Ms. Nondumi Somzobe, your hand is up. You are muted. Okay, I take it that you didn't really want to talk because your hand is off and then you still are muted. So can I then just proceed? So, and also in terms of the index and pagination, we know that a bundle must have 100 pages. We can't have 300 under one bundle or 400 or 500 even. You yourselves can't read that. How are we supposed to read that without it breaking off and letting loose all the papers? So it must be a stack of 100, obviously. So please, can we just agree on those few things, particularly the back to the font of the papers that is used in typing, because some make the font to be so small so that they can fit as much as they can in one page, which makes it so hard to read. And sometimes even the printing is so faint, but that will obviously be taken over, hopefully, by the case online, case lines. So maybe we won't focus so much on the printing because sometimes we get faint documents that we are unable to make out. The affidavits, I don't want to quote particular applications in case I'm seen as being biased or being against or whatever you might call it. But there are some where the legislation is just quoted and also case law for like 3 or 4 pages without you tying the particular legislation with the facts of your case. And we know that is not supposed to happen. So please, can we try to have our papers in order, particularly when we have regard to that. I'll stop there so that my colleagues can add, if anything, I'm sure they will. And also if you have any questions. Any contribution? Have I said it all?
No, JP, I'll say something. Can you hear me?
Yes, thanks, Rob. Yeah, thank you.
I think the two fonts, if I can remember correctly, the two fonts are either Times New Roman or Arial. I very often find papers where really fancy, ornate fonts are used, and it really is very off-putting. It is as if the person who's drafted the affidavit doesn't really want me to read it because it's difficult. So I would urge people to use the prescribed fonts and not these fancy cursives or ornamental fonts, which sometimes have like an oriental feel to them. Thank you, JP.
Thanks, Rob. I see there's a hand. You can go ahead. I think it's Mr. Mushepa or Miss Mushepa.
Hi, Judge. I'm not too sure if you, Judge President, if you're referring to me, but it's Advocate Sichava Mamwepa. Thank you for hosting the session.
Yes.
I'd like to ask a question. I'm from the Johannesburg Bar, and this is something that I see that some judges allow this side. I just want to hear maybe from your division in terms of quoting judgments or quoting legislation. I've been often told that we only quote a small paragraph if the law is trite, or if the law is generally known. But however, if you're referring to maybe a process or procedure that's not widely known to the bench or to the community, then you can refer to more passages in terms of your affidavit. Is this something that you would rather just have a small passage in it, or would you rather have the full document? I mean, more of the referring to the legislation or act or principle if it's not widely known. Is that something that you would allow?
Is this case law or is this legislation? Because in my understanding is that case law, not an affidavit, you will present that during argument. But my colleagues can correct me and they can say. But in terms of legislation, a little bit, and then you can expand it some other time. That is my understanding. Colleagues?
JP, I agree with you. I don't want to read that a man who fixes motor cars is telling me what the Constitutional Court decided in a certain case. Practitioners must realize they're drawing the affidavit not for themselves, but for their clients. If their clients have this knowledge, well, then perhaps it may be okay to mention it. But if they're not lawyers, why are they telling me about case law? Counsel can tell me about that when the matter is argued, as you said.
Yes, thank you. Any other view, colleagues? My colleagues?
I think, JP, what practitioners seems to fail to remember or take into account is the purpose of an affidavit, which is basically to place evidence before the court. Evidence and not the law. They can direct us where to find the law, and we will go and look for the law for ourselves. What is relevant, as Judge Mossop has said, is you don't want to be told by somebody what the law is, who would ordinarily not really know much about the law. We just need to focus on what is required. The facts are required as evidence under oath on an affidavit, not lessons on what the law is saying.
Agreed.
Thanks.
Thanks, Judge Masipa. Any other comment, colleagues? Are you covered, sorry, I think there's somebody.
Yes, good afternoon, JP and everyone.
Yes, Judge Sibia.
I just wanted to say that I think practitioners think that when they include that phrase in the affidavit, that submissions of a legal nature are made on the advice of those representing me, it then gives them carte blanche to go to town about the law. But that's not what that phrase is meant to do. So it doesn't then allow and I know the JP didn't want to mention the types of applications, etc., but it doesn't then qualify an RAF victim who is unemployed and stays somewhere very far away to be telling us what the law is on certain things that they obviously would never know.
Thank you, Judge Sibia. Thank you. Any other comments? There is a hand, Jonathan David. Yes, you may go ahead. You are muted. Jonathan, David, I don't know who it is, but you are muted. And can I ask other people to mute unless you will be talking? But please let your device be on mute. Yes, you may go ahead. All right, I think we will proceed. Any other comment, colleagues?
Okay, I'm unmuted now. Thank you.
Yes.
Yes, what I just wanted clarification as a relatively new attorney. What he's saying that even in a founding affidavit, case law should not be quoted, full stop,
Yes.
even though it's written by an attorney.
The founding affidavit is written by a litigant. It's my colleagues have just told you that it's evidence presented by the litigant, but it's drafted by the attorney. But it's a litigant that is deposing to the affidavit that is making their case, not the attorney or advocate. So I think the bottom line is this. The bottom line is this: is that case law should not be referred to unless there are exceptional circumstances, I would imagine. It should not be referred to on affidavit. You will refer to it when you are arguing your case, I'm sure. But it has no space in the affidavit because the affidavit is the evidence that you are presenting. And the case law is something that supports what you have stated as thinking it's correct in your affidavit. That is my understanding.
Thank you very much.
Thank you. Any other question? You can go ahead, just introduce yourself. All right, I think we'll proceed. Okay, so I hope we are clear now about the papers and what we expect, but I would like you to really just go through Practice Directive 62, and I think it's Uniform Rule 6. Judge Pedersen, am I correct about the rule? I think you tend to know them off by heart. I don't. But I'm not sure what is that uniform rule that we base our Practice Directive.
Sorry, JP, I was just looking at the practice directives now on my iPad. And I think what we must say to practitioners, they have to read the practice directive. It's quite intensive. It sets out what they must do. It deals with application procedures, etc., and things like that. And I think the big problem is that people are not reading, but coming to court and creating all these mistakes that are happening. So they have to read the practice directive if they're going to practice in the division in any event and acquaint themselves with it. That's in addition to the rules and of course the substantive law. Yeah, I think that's what I wanted to raise.
If I can just add,
Mrs. Mfusi?
It's
Yes.
Practice Directive 32. Yes, it's Practice Directive 32 and it's Uniform Rule 62.
Okay. So I've got it crossed. Yeah. Thank you so much.
Thanks.
Okay. Thank you. Mrs. Mfusi, I had asked that we stop admitting at quarter past, and it's really disturbing unless you have a way that it only comes to you. It's really disturbing, this view on lobby and what have you. So if you don't mind, they will get another one next time, or we can record and then we can give it to them. Yeah. And then Mr. Dwai, I think you had your hand up. You can unmute and proceed.
Thank you, JP. Perhaps my question was on that breadth of the affidavit. I wanted to establish on whether in an affidavit can then a litigant or a practitioner put an averment that during the hearing of this matter, I will argue.
No,
and then you put the point
you
that you're
can't.
going to argue.
You can't, because you will argue. So we don't need to. You will put it in your. You put it in your heads of argument. So you don't need to say you will argue, because we know you will argue and whatever you will argue. So we don't want that.
Thank you, JP. Thank you.
Thank you. And there was Ms. Hlachwayo. You can go ahead. Are you muted? You can carry on, Judge Bedison. Ms. Hlachwayo is still muted.
JP, I just wanted to remind everybody, if we go back to the basics, the founding affidavit is required in the first instance to disclose a cause of action, in the sense that it forms the equivalent in motion proceedings of a pleading in an action. Secondly, it is required to set out the evidence upon which the applicant relies. So people who are drafting required to have knowledge and appreciation of the substantive law that gives them, that gives rise to the cause of action. So they need to go back to basics when they drafting. And that's the basis upon which founding affidavits are drawn. And I think people are losing sight of the basics. You can't say it will be argued at the hearing X, Y, and Z, unfortunately, but they need to go back to the basics to work out what a founding affidavit must have, because it forms part of like the pleadings in an action, except here you have to have the evidence to support the facts upon which you rely for your cause of action.
Thanks,
Sorry,
thanks.
I don't mean
Judge
to teach,
Bedison.
but
No, this is part of the teaching. But, you know, the teaching is important because I think practitioners must be aware we have lots and lots of work, and we want it to work for us. We want it to work for you. It's a big frustration for us if your cause of action could have, or if your affidavit, founding affidavit could have been 6 pages, and all of a sudden it's 27 or 30 pages, which really is all over the show without making the particular point you are making. So we're trying to make it easy for you. We're trying to make it easy for us. So the teaching is important. So I think we have covered that ground. Miss Nelly Hlachwayo, unmute. You are muted. Okay, I just have to proceed, unfortunately, sorry. So I think we're done with the papers. With the papers, just on the papers, I noticed, and I think that the DJP and Judge Stein, Judge Masipa, whoever has acted as the DJP or JP or has done as a senior civil judge, often at the trial roll call, there is no statement of issues filed. And that is important, that it must be filed, because you want to know what it is that is the parties need you to determine, what it is that is still being disputed, or the essence of what you need to address and determine. So if we can just ensure that the trial file is indexed and paginated, but more importantly, the statement of issues is in the file. Because after this webinar, we have 2 weeks, we start trials, and we will strictly comply with what we have said. We had hoped that we could have this webinar just before recess, and so that when we start this session, we start on a clean slate of some sort. But unfortunately, we couldn't due to circumstances beyond our own control. So if we can ensure that we have that, and if you don't have, for the matters that will be called the week of the 4th, I think, of August, you need to ensure that you go and check with the registrar that your file is in order, because I can promise you and I can guarantee you, we will not entertain defects or deficiencies in papers, not after this, unfortunately. There was Advocate Moroka or somebody. Sorry, I didn't hear, my thing is jumping around. I don't know why. There was another hand though. Mrs. Mfosi? Koroma,
Thank you,
Advocate Koroma.
JP.
Yes,
Thank you,
Mrs.
JP.
Fosu,
My
yes.
apologies, JP. It seems like the system is not allowing us to block, but I'm going to try and just deny entry individually. I'm sorry for that beeping sound that will come through.
Okay, no, that's fine. No, it's fine. We can let it. It's fine. Don't stress. Advocate Koroma, you can unmute and carry on. Make your point.
Hello, thank you, JP. Back to the issue of what should contain an affidavit. Now, all that is dealt with in Erasmus, but we should know that that book is not available to all practitioners. The practice directive 9.4.6 gives a guidance as to what should contain in heads of argument. I think it would help practitioners who cannot afford books like Erasmus to have in the practice directive what is expected to contain in the founding affidavit as a guidance to those who may not have these fancy things like lexics, nexus, or the likes.
Thank you, Advocate Koroma. No, we won't have that. We won't. I see that Stein wants to say something. I'll let her say something just now, but we won't do that for the simple reason that there are libraries. The LPC, the last I knew, they have a library. There is a public library. There are universities around us. They have the libraries. Senior advocates, senior attorneys, everybody, they have libraries that have got these basic books. So there's no way we will. Otherwise, we will regulate everything in our practice directives. But people mustn't be lazy. They must go to the library. They must go to their colleagues and say, please, I want to just double check this. And besides, if we over-prescribe, that is going to get us into trouble again. As Judge said.
So, sorry, JP. Yes, in fact, you've said everything that I wanted to say. Everyone knows where a library is, and if they practice, unfortunately, Erasmus is the Bible of their High Court, as much as Buckles and Jones is the Bible for the lower court, and also the Criminal Procedure Act for criminal matters. So it's very necessary to please read these things for your matters. And this is not part of our practice manual. Our practice manual is for a guidance for those in our division. But you've said everything, and I wholly support what you've said.
Thank you, Judge Stein. Thank you. Thank you, Advocate Koroma. I just wanted to say, what did I want to say to you? I wanted to say, you'll be surprised. Everything that we're going to talk about tonight is everything that everybody knows, but they are not doing it. So, but thank you for that. Mr. Jonathan David, and then I need to move from this issue.
Yeah, okay.
You will be the last to say something, unless Hlatswayo still wants to say something, and they are able to unmute.
Okay. It might seem like flogging a dead horse, but I just want to clarify something. For example, in my founding affidavit, if I'm saying I'm using as my basis the latest case of that in order to make an accrual claim, would that be allowed?
You're making what?
I'm using the case of, say, ER versus EB.
Why must you say that? Why must you say that in an affidavit? You are not the litigant. The litigant says, I married this person in 1975 and we had an anti-nuptial contract, and I have a right to claim accrual because of that contract. Full stop. And I expect counsel, when they file their heads of argument, then they will say, what supports this averment is this. So we don't need this case law, Mr. David. I think we've made that point.
Well, I'm saying like post 84, things change.
No, I was just making an example. I was just making an example about 1975. It could have been 1995. But the point I'm making is there is no room for case law in affidavits. Counsel because the affidavit is by the litigant, I think that's what Judge Mosop, Judge Sibia, Judge Pedersen, and Judge Masipa have explained to you, that it is the litigant that is making the affidavit. You will then, as counsel, have an opportunity to then argue your case through the heads and then obviously orally in court. Thank you. I think we'll move. I will move from here unless Nelly Hlachwayo is able to unmute and talk. No. All right. I think just linked to court procedures before we go to dress code is the correspondence with the judges. The judges get correspondence sometimes directly to their email addresses because I think they are available somewhere. I don't know. But that is not permissible. That is not right. That is not allowed. Parties talk to the judge through the judge's registrar, and they address whatever they require through the registrar, and the judge will respond through the registrar. Sometimes the tone of the letters we receive leaves much to be desired. Sometimes there are ultimatums that if we don't grant a certain order, then blah, blah, blah. That is just not permissible. So we ought not to receive any correspondence directly to ourselves as judges directly, but through our secretaries. The candidate attorneys cannot and should not write to judges or their secretaries because the candidate attorney does not have a right of appearance in the High Court, nor a paralegal. A person that writes to the judge is the person that can be able to come when called upon to appear in an open court and explain themselves in that. With the Judge President's office and the Deputy Judge President, you write to the Chief Registrar. Whether you are writing about a matter you want to be case managed or you want preference, you write to the Chief Registrar for the attention of the Judge President or the Deputy Judge President or the acting JP or acting DJP, for the simple reason that you ought, when the judge, we don't know cases off by hand, off top of our heads. We don't know them. So we need that correspondence to be attached to the file so that we can make sense of what you are saying. It's a waste, absolute waste of time to write to my or DJP's registrar directly because they have to ask the registrar's office to get the file and then the file must come before us and we consider it. So that is what I wanted to say. And also, if there's an issue raised in an affidavit, and now another attorney or counsel want to respond, some write to us and say they want to respond to something they saw was being spoken about them in another affidavit. You can't do that. You respond by affidavit, not by a letter. So that's what I really wanted to say about correspondence to the judges or to their secretaries. It must be to the judges' secretaries. It must be to the chief registrar at times. No candidate attorneys or paralegals allowed, or your secretaries for that matter, because everything seemed to go. I think I'll let my colleagues add and say more. Judge Sibia.
Thank you, JP. I just wanted to add something that was quite basic back when we were doing articles, that when you are writing to the judge about a matter, you have to copy the other side. It's like approaching a judge in chambers about a matter. You don't go alone when you have an opponent. The other side must always be present and be aware of the communication that is taking place between the one representative and
somebody must, sorry, Judge Sibia. Can Mrs. Mfusi, can you mute everyone else so that they can unmute when they're talking, because somebody is just shouting at another for whatever. Sorry, Judge Sibia, sorry. Sorry, I interrupted you, Judge Sibia.
I was done, JP. I was
Okay,
just
thank you.
raising that point.
Thank you. Judge Hendricks?
Thank you, JP. These two issues that I'd like to raise in relation to the correspondence. One, legal practitioners tend to litigate via correspondence. If you are addressing correspondence to me or my secretary, please don't copy me or my secretary in trailing emails where they are essentially having a go at each other. That's inappropriate and unprofessional conduct in my view. Secondly, I think it's been emphasized that attorneys need to familiarize themselves not only with the uniform rules of court, but also the rules of practice and the practice directives. I'd like to encourage and say to practitioners, please don't write to my secretary asking me or her for advice on how to deal with a matter. Once again, it's inappropriate. That is what the Office of the Registrar is for, and those kind of queries ought to be addressed to the Chief Registrar or the Registrar in the General Office. Thank you, JP.
Thank you. Thank you, Judge Hendricks. Any other contribution to my colleagues first? All right. Any questions on that issue? I think it's clear enough. Ms. Yuste?
Afternoon, Judge. Thank you for that point. I think it's very well spoken. What I'm just wondering about, when it is sometimes appropriate to be dealing with a particular judge's registrar, is it at all possible to receive a list of which registrars is allocated to which judge, and perhaps a list of their email addresses and direct landline numbers? As things stand presently, if we call the direct line of the court, they usually give us a direct line for a particular registrar. Would that be possible at all?
I don't think so. I think you go through the registrar or the chief registrar. I think my colleagues can correct me if they believe we should be flexible. It should go through the registrar or the chief registrar, for the simple reason that the chief registrar must also be aware of what's happening between the litigants and the judges through their secretaries. And also sometimes secretaries are on leave. So it's best to really go through the registrar or the chief registrar, unless you know the judge's secretary. Colleagues? All right. Okay, thank you. I think I'll move then. I think hopefully you covered, Ms. Euste. Just on the issue of correspondence, linked with that is the issue of preference. People that are asking for preference, especially for hearing opposed motions. It's there on the practice directive as to what parties ought to do. But I want to emphasize what Judge Hendricks has said, and Judge Sibia, I think. When you write to the JP or the DJP or senior civil judge asking for preference, it ought to be a joint approach. If it is not a joint approach, you still copy the other side. You don't just write out of your own frolic to the JP or the DJP. But more importantly, we don't have long times for waiting for you to be allocated an opposed motion date. By the time you write to me and I take my time to answer, the dates are going. You could have gone to the registrar's office, get a date, hold the date if you are not satisfied and you believe your matter is so urgent, because preference is for very urgent matters and the case must be made out for urgency. It is not just for the mere asking. There must be a case made for the urgency as to why it ought to be heard outside the waiting time for opposed motions. We have less than 2 or 3 months waiting time in Durban, the same in Maritzburg, less than 2 or 3 months for opposed motions. Other people issue papers in 2021, 2022, and they run to me and ask for preference. What have you been doing all along? Even if it's issued in 2025 in January, and you took your own time dilly-dallying about filing affidavits, and now all of a sudden it's urgent, it must get preference. We don't have time because the people that made their papers in order and asked for dates also require that their matters be heard. So there must be a case made out for preference. You make a joint approach. If it is not a joint approach, you still copy the other side and you indicate that you had asked them, but they have refused. Hence, you are writing that. But please check with the registrar's office before you come and ask for a date, unless that date you believe is not suitable or for whatever reason, then and the case is made out for agency for preference, then you can come back. But I suggest that you, because often I just say go and ask for dates from the registrar, because there are dates, particularly in Durban, but also in Maritzburg as well. It's not bad. It's 2 or 3 months. So please, I think there was a hand, Fauzia Khan. I think I saw the name. But yes,
it was an
Fauzia
error,
Khan.
JP.
Okay,
Sorry, it was
that's
an error.
fine. Okay, thank you. You can lower your hand. Colleagues, do you need to add anything on the preference issue? Okay. All right, we'll move then. If there is no addition, especially by my colleagues, or there are no questions, but I think we've made the point. Then the dress code, or should I say etiquette in court, dress code, starting from dress code. Let me just allow Judge Nkosi first. Judge Nkosi? You muted.
Thanks, JP. Good evening,
Yes.
colleague. JP, the one issue I thought I would raise, the issue of the number of affidavits that parties are allowed to file. There are 3 affidavits that litigants are supposed to file. It's the finding, the answering, and the reply. But this happens particularly in urgent applications. When you find affidavits actually being flown left, right, and center, repeatedly, parties saying, I'm going to ask that this affidavit be admitted at the time when the matter is heard. But as a judge, then I have to read all those affidavits, even if I'm going to find that there's nothing which takes the matter further in any of them, and I decide not to accept them at the time of the hearing. So, but the question is, why do you have to file those affidavits knowing that you only have 3 affidavits that between the 2 of you are allowed to file in the first place? And take it that it's carte blanche just because you said you're going to ask the court to admit it, then you are free to do that. I think parties should actually refrain from doing that unless it's absolutely necessary that you have to file an additional affidavit.
Thank you, Judge Nkosi. I think that point is well made. Thank you. Right, then I'll move to the dress code. I think the term, I think I'd asked for 2 hours, but Mr. Mlaba and Mr. Mfosi gave us 1 hour. But let's see what we can cover, and hopefully we won't be cut if it gets to 6 o'clock because we started late. Just on the dress code and the High Court, I think we all know dark colors, black in particular, preferably black, and also a jacket and white shirt or a white bib, ladies' collar, but not the bib only, because other people come to court and they think we don't see that. They come to court with a bib only. There's no shirt, there's nothing, and they pull their gowns like that. It's hard for us, ladies and gentlemen, to correct your dress code in open court. It's embarrassing for you, especially in front of your clients. But sometimes we have to do it to correct the situation, because some of you are a bit senior and the younger ones are looking up to you and you're doing wrong things. So please, the jacket, in trial role, it's full. Also in motion court, I have to say to people, please can you button your jacket? You must all know it has taken me a lot in me trying to say, let me ignore it. But then I said, no, I can't ignore it because it's embarrassing to say, please button your jacket. You've never seen one single judge in the country coming to court with their jacket not buttoned, the shirt is out there and the bib and everything, and the gown. Because we all mature and gain weight, and maybe that jacket no longer is able to button, you pull your gown so that we don't see. So if we can please do that, and this applies both in criminal courts and in civil courts, both applications or trials, because other people think that because they are in before one particular judge in a trial, they can do as they please. The dress code is applicable across the board for everyone in all the courts in the High Court. Might I just also add, the bib must be clean. This is just for me now. The bib must be clean. Clean it every weekend. Just wash it, and then you go. But ladies, if it's a makeup, just clean it almost, as regular as you can. Let's be presentable. Let's have pride to come and appear before court for our clients. And again, I know that other people wear techies for health reasons. If you have to, it must be black, unfortunately, because you can't wear the ones that you're wearing over the weekend. Because when you come to my chambers and you're wearing techies that are white or whatever, you will not enter my chambers. And ladies, you cannot appear in the High Court with open toe shoes. The toes must be closed. We all know that. We're not going to enforce stockings because that's old age in me. But please, can we just be presentable and open, closed shoes so that if it happens that we stand the matter down, because you never know, the matter will be stood down and you have to go to the judge's chambers. And now you can't walk in because you are not dressed appropriately, because I don't. And for the attorneys that like to accompany counsel, we don't really like attorneys to come to our chambers. If counsel is there, you must have faith in your counsel. But if you have to come, you must have your jacket on at all times. You must be formal and presentable. That's the bit about the dress code. The dress code includes quite a few things. Well, the etiquette, talking over judges. The last I knew is that when a judge opens their mouth, counsel's mouth gets shut. You do not speak over and at the same time with the judge. You cannot do that. It's wrong, and it's a sign of disrespect. And when a senior colleague does that, it leaves much, much, much to be desired. And please, can I ask also senior colleagues, that is attorneys and advocates, when somebody is doing something wrong, please do correct them, because we also look up to you to correct them, unless of course you are the person that is doing the wrong. But please, that is one thing. And also don't put us against each other in terms of oh no, but your sister allows this. I'm not my sister in the Sibia J. I'm not Sibia J. She might allow it, or Judge Kosi or Judge Stein or Hendricks. They might allow it, but I don't allow it. So don't pity us against each other. And let's avoid forum shopping because you want to try your luck maybe on this issue. You hiding, you think that you can have some luck and the judge might not see that your papers are not really in order. Let's be honest and say these are the issues that I think might be a difficulty, but I will want to address them so that the judge knows that you have been forthright with them and you are honest. And when a judge addresses you, you cannot sit. You cannot be sitting. When I say, Mr. Nkosi, even if another counsel was still talking, when I say Mr. Nkosi, then Mr. Nkosi must stand up, and Mr. Singh, who I would not be talking to, can sit, because I'm directing myself at Mr. Nkosi, unless I want both of them to address me on something at the same time. But when a judge talks to counsel, counsel must stand up. Sometimes this doesn't happen. So I think I've said a lot about the etiquette in court, and I'll allow my colleagues to say something. And I think, yes, Judge Hendricks has got her hand. You can go ahead, Judge Hendricks.
Okay. Thank you, JP. These are just a couple of things I want to raise, JP, and we focus mainly on the civil side of things, but I'd like us to just re-emphasize that some basic principles that we ought to adhere to, especially when we're dealing with criminal matters, and more specifically the criminal pre-trials. More and more judicial practitioners are being appointed to deal with these matters. The practice, pre-trial minutes, the format has been, as I understand, distributed to members of the LPC. And I'd like to implore practitioners to familiarize themselves with it, but to also come to the pre-trial conferences prepared. It's not a tick box exercise. If I raise questions, I expect judicial practitioners to have consulted with their clients and to be able to address me on issues that I raise. More and more now, a practice is developing where people don't come prepared for pre-trial conferences. This not only prejudices the accused, but also where there are multiple accused, delays the allocation of trial dates. That's the first issue I want to raise. The second issue I want to raise in relation to this, JP, is where practitioners accept instructions, especially judicial instructions and instructions from Legal Aid South Africa. If for whatever reason they are no longer able to continue with the matter, I expect the legal practitioner to attend at court on the court date and formally withdraw. Not to just not pitch up, not to just send a message to a family member of the accused and say, I'm not coming. I considered it unprofessional conduct, and I will be reporting practitioners in the future after this meeting if that continues to happen. Lastly, JP, and I know it's a bit of a bugbear that I have, it's a pet hate of mine. In the High Court, practitioners don't ask to be excused. Once their matter is finalized and an order is issued, they are entitled to leave. That's the one thing. The second thing is there must always be two practitioners in a court. Members of the bar are familiar with that practice, but for those members of the Legal Practice Council, legal practitioners who are not, can I please encourage them to ensure that there are always two legal practitioners in court, especially motion court? Thank you, JP.
Thank you, Judge Hendricks. Thank you for all those points, particularly, especially the point about the withdrawals. I mean, we get people to say they phoned the prosecutor and they said they were withdrawing. That doesn't go like that. It goes exactly the way you said it does go. They must come and get to be excused. Ms. Judge Nkosi, is your hand still up? Or it's an old hand?
No, it is my hand. Thank you, JP.
Oh, yes. Thank you to JP. Sorry. Yes.
I'm sorry to join the meeting late. I had a problem with my mic and the speaker, so I do not know what was discussed and what has not been discussed yet. But I wanted to add something to the court etiquette.
Yes.
I've seen some counsel addressing the bench with hands in the pocket. It's either both hands or one hand and holding onto their hips. I don't think that is proper. I normally don't say anything to them at that stage to avoid embarrassing them. But I've noticed that some of them put their hands in their pockets when addressing the court. So I just wish we could do away with that type of thing when addressing the bench.
Thanks, DJP. DJP, this is an issue that I raised at some point, I think at tea or lunch, because I wanted, you know, in terms of our own culture now, in the Black community, when somebody puts their hands in the pocket, it says a lot. But I was told by one of my colleagues that sometimes counsel is nervous and they want to control their hands and they put it in the pocket. So that is the basis upon which I accept it. It doesn't happen often, but I accept it. But on the hip, no, not on the hip or on the waist. It cannot be. But maybe on the hand, I think we'll ask Advocate Moerane to tell us, to guide us in this one. Whilst Advocate Moerane is getting ready, can I ask Judge Mlaba? She has her hand. Judge Mlaba?
Oh, no.
Yes. Yes.
Thank
yes.
you. Thank you, JP. I also need to apologize for having joined the meeting late.
No problem.
But what I wanted to raise is that whilst we're talking about etiquette, just to implore on the practitioners that when there are more than one judge sitting, please just be courteous enough and address both judges. It doesn't matter if you are sitting with a senior, well, a judge would be considered to be senior, but you are there as a judge. You also want, you know, counsel to address or just to look at you, even if they're not addressing you personally, but acknowledge that there's more than one person there sitting and listening to you. And secondly, JP, I know you talked about counsel wearing techies. I've heard those incidences. What is required is that judges, counsel wear the closed shoes, you know, shoes, formal shoes. But if you have an issue with your feet, at least let me know beforehand, because yeah, even if they are black, or even if they are or slippers for that matter, just let me know so that I also understand that there is an issue involved. That's it. Thank you, JP.
Thank you, Judge Mlaba. Thank you for that. Mr. Singh?
JP?
Yes.
Oh.
Yes, Essie.
Sorry if I interrupted somebody.
No problem. No, you can carry on. I had asked you actually to assist us.
Yeah. Well, I was involved in a case in Joburg a few years ago, and my junior was doing the cross-examination, and the judge actually upbraided him for putting his hand in his pocket. It was actually the first time I came across that. I wasn't aware of that rule or that convention. I don't know. I think it's a question of personal choice, really. As the JP said, some people do that, you know, to try and calm themselves down. Because if their hands are out, they might be seen to be shaking and trembling and doing all sorts of things. But as I say, it's a matter of individual judges. Some judges object to that, like the one I mentioned, but others really do not bother about that. But I never put my hand in my pocket in any event when I address judges. But as for putting your hand on your hip, that seems to be a loaded statement of conduct. Yes. Thanks.
That's a confrontation.
Thanks, JP.
Thanks, Advocate Moerane. Advocate Singh. Advocate Singh, you are muted. Yes.
Good afternoon, Judge. I'm with the Asset Forfeiture Unit in KZN, and some of our applications consist of Section 38, which is brought ex parte and in chambers. And sometimes with correspondence, we inform the judge or the judge.
I can't hear you, Miss Singh. I seem to have
JP,
lost
can
you.
you hear me now?
Yes, I can hear you now. Yeah.
Good afternoon, JP and
Yes,
colleagues.
no, I can hear you. You were saying you sometimes the correspondence.
JP, I'm with the Asset Forfeiture Unit, and some of our most of our applications are brought ex parte and in chambers. And sometimes it is no need for the judge to read the papers because we're going to remove Section 48 out of the roll. In that scenario, must we still write to the chief registrar, or can we write to the judge's secretary just to inform judge not to read the papers?
If you know the judge's secretary, you can write to the judge's secretary, but there's nothing stopping you from writing to the registrar and copy the judge's secretary, just in case the judge's secretary is not there for whatever reason, so that the registrar can also inform the judge. Write to the registrar and copy the secretary, or vice versa, either way. Thank you
JP, for clarity.
Okay. Mr. Mzulwini and then Ms. Ramota. You can unmute. Mr. Mzulwini, unmute. Yes.
Good evening, Judge. How are you?
Yes.
Judge, I just wanted to, in a way, raise this particular point, and I also joined the meeting late, so I might have missed what has been said. But from the little bit that I've heard in the last couple of minutes, there is something that is worryingly striking. It's that there is the setting of a protocol that is not properly published. And by that, I mean is that, for example, when people complain about hands in pockets, hands on hips, those conventions are possibly not generally known. And I'm not disagreeing with them. I must make that clear. But for example, as an attorney, those conventions and protocols are not properly related or publicized to us. So the point I make is this: when we make protocols and conventions, in order for them to be observed, can they be properly published so that all of us know what is expected, what is not, and what is unexpected? And secondly, just to make a general point, and this is I'm not going to call it a frustration, but it's an observation that I've seen. There's a tendency within the operations of court that if you do not know the secretaries or the court officials, you really have a hard time trying to find your way or navigating your way in court. So, and I'm going to make an example of this. So what you do is that you will you will try to issue papers or try to do something, but the court in Durban will say, "Oh no, you have to go to this office," and the court in Pietermaritzburg will say, "Oh no, you have to go to this office." Can we have a centralization and a formalization of protocols and processes
so that any practitioner, whether they come from Limpopo, whether they come from Northwest, they know exactly what they need to do in this court.
Thank you, Mr. Mzulwini. So I'll get some of my colleagues to comment, but perhaps just to say that the practice directives are the starting point. Most of the things that we are talking about are under practice directives. The conventions about practice in the High Court, that is mostly found in the advocate's profession, because as you will know, the attorneys never used to practice in the High Court, it was the advocates. And we've gone on with those conventions. And I don't know if there's anything that we can do on the side as the bench. We've got our own guiding issues when people come to act to make themselves comfortable. We've tried to have all those in writing, but I don't know as to how much can you go in terms of the practitioners themselves. But I'll let some of my colleagues to comment. And I think if we can try to make our comments quite brief, then we can proceed.
Without interrupting, Judge, before they do.
Yes, and that's what I was complaining about. You were talking whilst I was talking. You ought to wait for me to finish and then you can make your point. Yes, you can proceed.
No,
proceed, Mr. Mzolweni.
I was just saying that, does that not then, when you say that it is the conventions from the advocate's profession, does not that then put the attorneys who may wish to someday ascend to the bench at a prejudice because the conventions are only from the advocate's profession?
You haven't listened to me properly, and that's what counsel does in court, because I have said most of the conventions are from the advocate's profession because attorneys never used to practice in the High Court. Hence, there is that difficulty. And then I invited some of my colleagues to comment to see how we can assist before you ask me the question. So let me just get Judge Pedersen to see how we can assist in terms of the advocates, of the attorneys. But most attorneys who practice in the High Court have familiarized themselves with the practice. Hence, Judge Hendricks was alluding to the fact that there should be no less than 2 counsel in court, just mentioning it here. The hands issue, whether in the High Court or in the Match Court, I think it applies. It's just the etiquette in court. But let me let Judge Pedersen comment, and I think Judge Hendricks can also comment.
Thank you, JP. I just want to point out, when we talk about counsel, we're talking about attorneys and advocates as we understand it. But the counsel must be respectful and courteous to the judge, other legal professionals, and all participants in the proceedings. This includes maintaining appropriate decorum and avoiding disruptive behavior. There's no magic to that, JP. And all it means is that you must act with decorum and good manners and be respectful to not only the judge, but your colleagues who are your opponents. So that's what we were taught at the bar. There's no magic to it. It doesn't have to be codified. I think every legal practitioner who practices in court knows that this is the ethical standard that must be maintained. So there's no magic to it. You know, when we talk about the advocates coming with the conventions, that is the convention we were taught, but there's nothing more than showing good manners, like how you teach your children at home. For example, when you go around introducing yourself to colleagues, that's what we're talking about. So the same applies in court. Thank you, Jay.
Thank you, Judge Pedersen. And perhaps Ms. Advocate Mlaba and Ms. Mfosi, is something that you can take up within the Legal Practice Council and see how you can assist all practitioners that come to appear in the High Court, how to familiarize themselves with the practices in the High Court, and if there's a need to have in writing all the conventions. It's something that I think you can take up. I saw Judge Mlaba, is that an old hand, or you want to say something? And then Judge Masipa. I'll come to Advocate Ramotha just now. Judge Mlaba?
No, it's an old hand,
It's
JP.
an old hand.
Apologies.
Okay, thank you. No problem. Judge Masipa and then Advocate Ramotha.
Thank you, JP. I think what Judge Pedersen said should not be anything new from even attorneys, because it's things that we've been taught. We were taught these things from PLT, that this is how you conduct yourself towards your colleagues, towards the court and all of those things. So that it has to go and be written somewhere, I'm not too sure of. But the issue is it's something that we have to expect that all practitioners, whether you're an attorney or an advocate, should know and should be familiar with. That's all that I wanted to say. Thank you.
Thank you, Judge Masipa. I hope you covered Mr. Mzolweni, but I hope you sorted. Advocate Ramotha.
Thank you. Good evening, JP. Good evening, judges. I just want to pick up on Judge Hendrick's comments, and specifically with regards to practitioners withdrawing in matters. And I would like clarity from the bench, because it seems that in recent times, the trend has been for practitioners to simply announce their withdrawal. Am I correct that the procedure is to apply to withdraw from the matter? That's the first thing. And then secondly, with regards to court times, JP, we have chatted in many a time about the issue with practitioners being late on both sides. What is the correct procedure? Because often I find that we are the conveyors of messages from practitioners who are running late or who are not going to attend court on time, and we are then supposed to be relaying the message. Is the correct procedure to inform the registrar? Thank you, JP.
Thank you. Yeah, you're correct. The procedure is for the practitioner to come to court and apply, and then that judges entertain that application to withdraw because of whatever reasons. And the court times really are in the civil matters or as prescribed by a judge, 9:30 trial roll call and applications. Criminal trials, it's 10 o'clock or 9:30, depending on what the judge says. 9:30 or 10 o'clock, and we finish at 4, not at 3:30 or 3:45. Those are the times. And if for whatever reason there is an accident somewhere, there is that tendency for people to ask another colleague to convey. We'll leave that at that, because I don't encourage it, but you do want to be made aware. So I think there's nothing wrong with somebody asking for a prosecutor or your registrar to convey the message that they're running late for whatever reason. But it must be a very good reason for you to keep the court waiting. I'm going to allow Judge Hendricks, but I just want to add, Judge Hendricks, something before I let you proceed. Just 2 or 3 things that have just been brought to my attention. In court, people they chew gum and they use their cell phones. They're playing when the matter is not entertaining them. So if we can please, sweets, chewing of gum, and drinking, you can't drink from anything other than a clear bottle. It must be water specifically or something clear. Nothing else is allowed that you must drink or sip in court. Judge Hendricks, and then I'll allow Nkosi Ngipile. I don't know the full name, but it's Nkosi Muzunze. Yes, Nkosi Ngipile Muzunze, but after Judge Hendricks. You can lower your hand, Mr. Mzolweni. Thank you.
Thank you, JP. Can I just address one of the aspects that I don't think has been answered in relation to queries that Mr. Mzolweni's raised? If there are questions in relation to the procedure in either the Durban or the Pietermaritzburg High Court, there's nothing stopping practitioners from asking to see, we have a senior registrar in Pietermaritzburg, we also have a chief registrar, as well as a chief registrar in Durban. And I encourage him to do that if anything in relation to the procedures are not clear, or if there's any confusion that arises. I just want to add to what you said about withdrawing. practitioners seem to think that it's a given that they can come to court and say, well, I want to withdraw. It's in the discretion of a judge to grant them leave to withdraw. I don't have the authorities before me now, but there are several authorities which says it's within the discretion of the judge. If it's on a trial date, there've got to be very good reasons that application for withdrawal is made. And more specifically, if the trial is started or commenced, or if the interlocutory application is commenced in criminal proceedings, it's still within the discretion of the presiding officer to allow a practitioner to withdraw. I'd also discourage the officers of the DPP and the prosecutors from relaying messages. We have registrars. Our registrars and our secretaries can be contacted if there are any issues as to why practitioners are not in court or why they're running late. Thank you, JP.
Thank you. Thank you, Judge Hendricks. And I think just to add to the point to Mr. Mzulwini about the practice in Durban might not be the same as in Maritzburg, we are working towards making sure that everything works the same. So if that was the point, I just accept what the Chief Registrar says. As Judge Hendricks has said, you can just verify with the Chief Registrar whatever you're not happy with. Nkosi Ngiphile Muzenzeni.
Afternoon, Judge, President. I'm covered. I'm covered with the issue of the unopposed motion, whereby the other party has filed the withdrawal notice of opposition and intention to abide by the decision of the court. My colleague has just clarified that it's not necessary to file the heads of arguments if it's not needed.
Okay, thank
you so much.
That was just a comment you covered. Okay, thank you. Themba Matenja, we just have to move quickly because there's quite a few things that we still have to cover. Themba Matenja.
Thank you, JP, and thank you, judges, for the powerful training on ethics. We really needed it. JP, I want to check, firstly, on the issue of dress code. I don't think, JP, you have to feel pity for practitioners if they are not dressed properly. Even if you don't go into details, just to say, may you please go out and dress properly before you can address me, even if it's an issue of buttoning a jacket or whatever it is. Because as you said earlier on, it became a trend, and the juniors are going to learn a bad thing from the seniors. Then in future, when you reprimand one junior, then they will start to compare to say, but senior counsel so-and-so was not told to dress properly, so it's because it's me. Why? Because they take it from the seniors as if it is fine. It is not fine whether with a senior or with a junior. I want to check with the issue of a dark navy blue suit. Is it allowed that you can, as a practitioner, be dressed on a dark navy blue suit with all the other components, be it a bib and a white shirt and the likes? Then one more aspect, I want to check in relation to withdrawal. Wouldn't it suffice to file a notice of withdrawal even if it's a criminal matter? Like instance, we are having a trial that will be coming next year, and I understand that we are not going accordingly with my clients. Then I properly serve to the NPA as well as other practitioners if they are there, and to the registrar of the court. I serve and file a notice of withdrawal that I will be withdrawing in this case. I understand that it is not a given that automatically by saying I'm withdrawing, you will be excused, especially if the matter hasn't started. Because one other aspect will be, if I go to court on that particular day and the client has already indicated that he no longer needs my services, who is going to pay for my fees for that particular day? Hence, I'm asking, wouldn't it suffice if I serve and file a notice of withdrawal as it is done in civil? Thank you very much, JP.
Thank you, Mr. Matenja. And then I'll allow Advocate Kumal. I think his hand or her hand was up. No, the notice of withdrawal is not allowed in criminal matters. We do pre-trial conferences now. And for that reason, we check whether you have been placed in funds. By the time we set a trial date, you are committing yourself that you will proceed with the trial on that particular day. And I promise it's becoming a problem to get counsel to be available for their criminal matters. And we really have to do something. I don't know what is it that we can do for people when they commit, that the set trial is set for that date, that they will be available, they will come and attend. Who will pay you is between you and your client, because you are committing on the date of the pre-trial, when you set the trial date, that you will be available. And also, as you have correctly said, it's an application, especially in a criminal trial. It's an application that you're making. So there's no way you can all of a sudden just file a notice of withdrawal. You have to come and make an application, and the judge can consider it in its merits. With regard to the colors of the suits, let's just stick to black. I think it's safer, because blue, as we know, blue can be navy or this blue, and whatever. Let's stick to black. It's make our lives easier, all of us. Blue or probably dark gray, but blue. Let's stick to black. I think, please. Colleagues, on the issue raised by Mr. Matenja about withdrawals, are you agreeable, or you have a different view, or you want to add something? Okay, I'll take it that you're happy with that response. Okay, thank you. Advocate Kumalo, are you still online? You had your hand up. Sorry, I forgot. Okay, and then Mr. Dwai, I think Advocate Kumalo might have left or no longer want to pursue. Mr. Dwai, you have your hand up, or is that an old hand? If the people that have spoken can lower their hands, Mr. Matenjo, you can lower your hand, and Kosingi Pile Muzenzeni, you can lower your hand. Mr. Dwai, do you still have a...
Thank you, JP. I do have a point. By the way, it's a comment. I've seen that during the court proceedings, you'll find that some matters will be stood down for attorneys or practitioners to deal with their issues, and then be called later on later on. Then what I would suggest to my colleagues is that at least you must show an utmost respect to the court, at least by to be thankful to the court for giving us those indulgences. You'll find that the practitioners will just rise and confirm their appearances and address the court without having at least showing a respect of being thankful to the court, to say, I am thankful to the court for giving me such an indulgence, and then you proceed to address. That is also the part of showing the respect to the court and part of the court etiquette. That is all, JP. Thank you.
Thank you, Mr. Dwight. That is a good point. People take things for granted, you see, so that's why. All right, thank you. Then Mr. Mzulwini, you have your hand up.
Thank you, JP. I just wanted to make a point, and I think it may be abstract, but in relation to the issue of withdrawals, my view on it is this. I think there has to be a deliberate and earnest and honest use of the pre-trial procedures. And here's why I say that. It's because oftentimes, if you just go through the motions, it will then lead you to an eventuality where you will then have to seek for an adjournment or a postponement because there's something that has to be dealt with. But I think it is incumbent upon practitioners using the pre-trial tools that are fully provided for to simplify and isolate or centralize the issues that the court has to deal with. And this will result in two things. One, less reading for the judges. Number two, a sharper focus on the actual issues. But that is a duty that I think is incumbent upon practitioners. And the reason I say it is incumbent upon practitioners is because there sometimes seems to be occasions where it is used as a tactical tool. When someone says, I don't want to show my cards yet, I'm playing my cards close to my chest. And what you then find at the end is then now we have to postpone, now we have to adjourn. So at the end of it, I think it is just a plea from me, or a suggestion from me that can we please use the pre-trial mechanisms that are already there? There's no need to over-regulate them anymore. They are there. Can we just use them properly?
Thanks, Mr. Mzolweni. Yes, I think your colleagues have heard it. We are getting stricter and stricter on our side on the pre-trial conferences. So everybody must adhere to that, and we must all comply with what we promise to do. Colleagues, is there anything else that you want to add there so that I can move? We have few minutes left. We've covered quite a few things, and maybe this one next. Maybe on the okay, maybe it will come here on the double booking. I think it was an offense, and it still remains offense. It still is impermissible for counsel to double book themselves. Double booking means you appear in unopposed motion and you have a special opposed motion before another judge. You make one of the judges to wait. Don't be greedy. Take one brief a day, because it is wrong for you to double book. For you to start in unopposed motion and you've got a criminal matter, and for some reason now we must make means to accommodate that person because they're in another court. Please do not double book yourself. It is an offense, it's unprofessional conduct, and you're making the court wait. We've got very limited time and we don't want to waste any time that we just don't have. I'll allow my colleagues to comment, but before I allow them to comment, I just want to add this issue, particularly on the on the practitioners that practice criminal law. Please, can you try to limit your briefs, especially in long matters, because we are going to be having, come January 2026, we have started already with the back-to-back sessions. We're going to have criminal sessions for a term, for as long as judges allow it, because it's quite strenuous, but some do allow it. So for as long as judges allow it, when we set the matter down, we must set it down for the term or for 2 terms, because matters must start and finish. We've got quite a huge backlog of parties and matters that are just proceeding forever. So we need to finish matters and we need to get them to start. So double booking, and also get rid of some of the briefs. Don't clog the roles because you are the special experts. Let me use that word. Experts in the criminal matter, because you can't be in all courts and the courts need to proceed. Criminal trials must proceed. So I'll allow Judge Nkosi And then there's Wandi Sishi and Damian Bond. But let me allow Judge Nkosi and see whether some of my colleagues have anything before I call on the practitioners. Judge M.E. Nkosi.
JP, thanks. Let me take this opportunity to mention a prevalent practice during case management when practitioners would say they've held a pre-trial conference, and when you look at the papers, you only find that they held it by themselves. It's not a conference if you hold it by yourself. So the proper thing to say if you just couldn't get hold of the other side is to stipulate that the pre-trial conference has not been held. Because if you say it has been held, and then when the judge looks through the papers, it's only you, and you say it was held by the one side, you are misleading the court. And the court will end up certifying the matter ready for trial, only to find that the pre-trial conference has not been held. So I'm very strict when I look at the judicial case management matters to ensure that there's been compliance. And if you say you held a pre-trial conference and you haven't, I take a very dim view of that. That's me, though.
Thank you, Judge Nkosi. Most of us take that dim view. Thank you. Any other comment, my colleagues? Thank you. That's a point well made, especially for even Judge Nkosi, even for the expedited matters on the trial roll. That is a big tendency. They hold pre-trials by themselves, but they should say they couldn't hold it because of ABC. And then, that is the proper thing. So I think that's a point well made. Any other comment from my colleagues before I allow Sishi and Bond? Okay, Sishi. I can't say Mr. or Miss because I don't know. So allow me to just use this, what I believe is the surnames. Yes, you can carry on.
Thank you, JP, and thank you very much for this platform. I am a miss, but I do understand it's difficult to tell. I thank you very much for this platform. Just with the reference to double booking, sometimes you find that you're in court and it looks like the attorneys have actually double booked themselves, but they send their clients to court to sort of be a placeholder for them. So they put you in a position where the attorneys aren't at court, but the clients are at court unrepresented, and the matter has to drag on for time. What steps can be taken in those instances? Because you then just want an adjournment, but the attorneys have sent their clients to court to sort of be like a placeholder in the interim, just to prevent that. And sometimes it's on more than one occasion with one party. And then secondly, if the pre-trial is essentially being avoided, or you can sense that there's some form of a dilatory tactic that's being done, and you then file a pre-trial minute, but you specify to the court to the fact that you were unable to hold a pre-trial because of the other party being served but not responding and not responding to calls, but you want to proceed with the matter because you are, for instance, the plaintiff in the matter, and you want to make the matter to proceed, and you sense dilatory tactics. Is it still acceptable? Will the matter still be certified trial ready if you do file a pre-trial minute indicating to the court that the other party is not coming to the party, and with the issue of the advocate, the attorneys as well?
I think Judge Nkosi has just addressed that you must be specific that you could not hold it because of these reasons. So the latter part of your question has got the answer. But about the attorneys sending their clients for placeholder, if counsel is not in court when the matter is called, then the judge will deal with the matter. There is no placeholding. We don't do that. And quite frankly, I strike matters. I think some of you know by now. I strike the matters off the roll if there is no appearance. And when people come and explain, I refuse because they were not in court when I started court. So there is no way that we can allow that. There's no place holding or anything like that. If you're not in court, there must be a cogent reason why you're not in court. And the judge will deal with the matter, but parties are expected to be in court. So that is really the prerogative of the particular judge that is before you, but not for place holding and wait and making us wait. I hope you are covered, but I saw Judge Mogere and Judge Hendricks have got their hands. Judge Mogere, Masipa, sorry.
Thank you, JP. I wanted to just deal with that issue of the pre-trial conference and the subsequent minute. The rules provide that parties will hold a pre-trial conference. So it is expected that the the applicant and the respondent, or the plaintiff and the defendant, are holding a pretrial conference together. So there's no provision for a single-sided minute to be filed at court. And I think even at taxation is going to be a problem because it's not provided for. So I think we know that when the one side does not respond to the pretrial invitation, there's processes that provide that practitioners must follow to get them to compel them to attend to the conference, to probably even an extent of getting their defense struck off for not complying with the rules and all of those things. But then I'm not aware, and I always struggle with the issue of one-sided pretrial conference. There's nothing wrong with filing a document to advise the court what the status of the matter is from the one side, but a pretrial minute, single-sided, I'm not too sure the basis of that. Thank you.
Thank you. Please mute. There's somebody who's talking whilst you're talking. Judge Hendricks, and then I'll allow Mr. Bond.
JP, coming back to this aspect of pretrial conferences, both Rule 37 and Rule 37A make provision for parties to approach the case law registrars for the matter to be placed before a judge, for a judge to convene a pretrial conference before them. So I don't understand why we're still having pretrial minutes with one attorney.
Thank you. So we must just go back to the rules and see what they provide for. If the other party is running around, and then they must, in fact, they request that the pretrial must be convened before a judge, or they even ask you to case manage it, case management meetings. Thank you for that, colleagues. Mr. Bond.
Thank you, JP, for the opportunity. Just on the issue of double booking, a memorandum was sent out by the Bar Council about a year ago or so, which indicated that counsel were permitted to appear in both unopposed and opposed matters, even though the opposed matter may be allocated out of the normal motion court. The issue we have is at times the opposed motion may be in the normal motion court with the unopposed matters, and at other times it's allocated out. And as practitioners, we only get the role after midday, about 2 days before the matter's heard, and at other times we only see the allocations on the actual day of the hearing. Now, we understand fully that things like taking a trial brief and a motion brief is completely out of the question, but historically, as far as I am aware, it's been understood that allocated opposed motions are merely an extension of the normal motion court. So we'll just ask if we could have clarity on this, because I know it affects a lot of practitioners, and it obviously is difficult at times where you have an opposed motion and there may be an urgent application in which you are responding, and that obviously would then be in the normal motion court. Thank you.
Thank you. Thank you for that. So the motion court, Monday, Wednesday, Friday, everything there is in motion court with the two opposed motions. But on a Tuesday and a Thursday, there's a special role for opposed matters, and you will know that when you go and get a date, because the registrar will tell you that matter either on a Tuesday or a Thursday, it's either in motion court or it's in the opposed trial role that gets to be before the JP or the GJP, which they allocate to various judges. So on a Tuesday and a Thursday, I would suggest that you don't take any opposed motion outside the motion court role. The registrar they know that. And so it ought not to happen on a Monday or Wednesday. If there's a special opposed, again, you will get to know that it's a special opposed, special allocation, so it cannot be in motion court. That's how you can differentiate it, Mr. Bond. I hope I have covered you. I don't know if colleagues wants to add anything that I might have left out.
Thank you, JP.
Thank
JP,
you. Yes,
sorry,
yes,
JP, can I just add
yes,
that colleagues, practitioners must also remember that apart from there being two motion courts on a Friday in Durban, there's also L Court and J Court, L Court in Durban and J Court in Maritzburg. You can't have an opposed in L Court and J Court and also have an opposed in Motion Court. Those courts run at the same time.
Thank you, Judge Hendricks. I think we've dealt with that. Maybe just on the Motion Court, I know that I didn't have this. There's a tendency and there's a new practice which is illegal and it's fraud and it's dishonesty. People file notices of set down for applications that they have not prepared yet for them to secure dates. When we discover that, we will send it to the police because it's fraud. You're committing fraud to the court. You're presenting as if there is an application. We'll send it both to the police and to the Legal Practice Council because it's dishonesty. You're being dishonest that you've got the affidavit, because what happens is there's a notice of set down, but the affidavit is dated 3 weeks before the matter is heard. So obviously they just went to the registrar's office and they got the notice of motion, which was stamped and served, but there was no affidavit or any of the other attachments that were there. So please, if we can just refrain from perpetuating things that are illegal or that are not permitted. I have only one other issue, and I do want us to finish in the next 5-10 minutes. So is there anything that you colleagues want to add on that issue on the Motion Court? Okay. Judge Hendricks?
JP, just one more thing. Certificates of urgency. I just want to remind practitioners to familiarize themselves with our practice directives, which make provision for presiding officers in the event of a certificate of urgency being signed and a matter is not urgent. There's a provision in our practice directives to issue a rule NISA for the practitioner who signed that certificate to show cause why they ought not to pay the costs of the matter being struck off the roll for want of urgency, de bonus propri. I'd like to appeal to practitioners to make 110% sure that when they sign a certificate of urgency, they satisfy themselves that the matter is urgent. Thank you, JP.
Thank you. And might I just add there, Judge Hendricks, that you cannot sign on a certificate of urgency on an unsigned affidavit. That is not an affidavit, I think we all know. So the certificate of urgency is signed on the papers that are ready to be presented to court. Judge Masipa? And then Mr. Mzolini, I'll allow you briefly.
Yeah, thank you, JP. So I've had instances where I don't know, I think practitioners are aware that the way our role is structured, for instance, there would be a certain number of Rule 46 applications, and I think those RAF PAJA matters. So I had instances where I would have a very thick file and read through the file, and somewhere towards the end there, find that somewhere slotted is an application for substituted service. When you look at the role, it's actually written Rule 46A. So the Rule 46A is actually the application that is set down, and then there's a substitute service. So when I try to investigate this with the people from the general office, they tell me that no, what practitioners do is they come, they ask for a date for Rule 46A, and which is given, and then they attempt service. And when service fails, they unilaterally change and slot in that substitute service as the application that would be had, whereas they basically blocked other Rule 46A applications which could have been slotted. The General Office has requested practitioners, please, when you're not going to be proceeding with the Rule 46A, come and remove your Rule 46A so we can slot another one because of the limited numbers that we can slot of these types of matters. But this continues to happen, and that's the first thing. The second thing is that substituted service will be slotted there at the back. you read everything else only to find that there's a 10-page application, which is allegedly supposed to be the application that they're now pursuing. You've taken your whole time reading a Rule 46A for nothing. So I think when you indicated earlier, when you started addressing practitioners, that they need to be clear on which application they're pursuing, but then they must not, in the middle of a Rule 46A application, decide to swap the application into a substituted service application. Thank you.
Thank you. Thank you so much, Judge Masipa. Mr. Mzulwini, very briefly, please, and thereafter, Ms. Yuste, also very briefly.
Thank you, JP. It was in relation to the issue of set down, and in specific relation to the issue of the indexing and pagination of papers. So I've had an occasion, and I'm not speaking about me personally, where when you launch the initial application, which is on an urgent basis, you do them with an index, but then on the date of the hearing, the matter is not placed on the roll because you are told that, well, you did not index and paginate, whereas the papers are, with the initial papers that are filed, are indexed and paginated. So can we just get clarity as to how that should work, especially in relation to urgent matters?
Yes.
Mr. Mzulwini, I don't think there is a very strict compliance issues with urgent matters, and I think my colleagues will correct me if I'm wrong. But what is required, well, now we've got case lines because people used to just come with copies. Meantime, they didn't bring the originals, but that falls out of line. But when there's an opportunity, you must index and paginate. But when you did not, you need to explain yourself before the judge asks the question. But I haven't come across that, colleagues. Does anybody wants to answer that quickly? It seems like I've got it right then, Mr. Mzulwini. And then Ms. Yuste, quickly. Ms. Yuste, sorry.
Thank you, Judge. Just to go off of what Judge Masipa indicated about rather removing Rule 46As to make space given the limited space available for Rule 46As, am I then correct in understanding that it is an acceptable practice that if a Rule 46A is removed from a roll, for example, let's say for September, that we are then allowed to then, when a new Rule 40, a different matter, a Rule 46A is issued, that essentially a space is opened up for that date in September, and that we are allowed to set it down for September as opposed to being pushed down to the next normal available date, which is currently, I believe, February or March. That is an acceptable practice. Might I just have clarification on that?
I don't think so, Ms. Yuste. When you remove your matter, the space becomes available. Then it's up to the registrar and their discretion to see which matter they fit in, whether it's your matter or another practitioner, because the particular matter that was on the roll has been removed and the space has become available. So it's a discretion of the registrar as to who then gets that space. I hope that covers. Vika Ngasa, quickly, and I need to get to the next point so that we can finish. We have literally
Good
3-5
evening,
minutes.
JP.
Yes.
Mine is just short. I thought your agenda was going to trickle down to court online system, but it's a small matter. Hence, I hear that.
My next point will be court online. So,
okay.
Just hold your comment and maybe let me get to that. The next one is court online. Practitioners are not bundling documents. And they are not doing it properly, even the uploading of documents. We need to make sure that we comply. The practice directives are on the way. We're just finalizing them as the bench, and we will put it out to the Legal Practice Council members, all of them, for comment. But they are coming. But the one urgent issue for now is the bundling of documents. The practitioners must bundle. Sometimes the network is not working, but the registrar's office will let you know what to do in such circumstances. So I don't know if there is anything else that you want to ask about that. We have 5 minutes left. Mr. Ngasa, what did you want to raise?
It's just our lady who starts cases on the system in our office has asked me to ask at least for an assistance to Ronel. She says that there's a difference between Durban and Maritzburg in terms of when we start our preservation cases. When she starts the preservation cases, she writes to the registrar in Durban, and then she uploads the notice of motion, and then she gets a date, and then she gets the judge's secretary contacts details. And
let me just cut you short. Sorry, Mr. Ngas, I don't mean to do that. So that we keep it short. I've been made aware that there's a difference between how Durban does it.
Yes.
When processes are being started. My registrar actually had a meeting today with the chief registrar in Maritzburg, and I asked them to speak to the chief registrar in Durban or with the registrar dealing with general office and court online. So they are working on that. But I'm going to, from which office are you from?
From the AFU, madam.
Asset forfeiture. Okay, I'll get them to. And your lady's name is?
Is Nondombanza, who starts
Nondombanza. Okay, I'll get them to address that issue as well. Anything else? Because we literally have 4 minutes.
Thank you, JP.
And I think I didn't go to the comments on the chat and all of that. Ms. Mfusi will get them for me so that we can answer them. But one was whether you robe when you are in the gallery. No, you don't robe when you are in the gallery. You haven't come to appear. So I don't know if there's anything else. So I think let's leave it at that. Colleagues, is there anything that you want to say in closing? Because we are going to be cut off at 7. Yes, Judge Masipa?
I just want to say in respect of the issues relating to the problems that practitioners are having with bundling, a couple of them have indicated that they're trying to call the call center and they're having problems getting through because we are apparently having one line, for instance, in Durban, and the lady indicated people are taking too long for assistance. There's the national call center line that they can approach, and we otherwise addressing the issue to try and see if we can get further assistance. Thank you.
Okay, thank you. And I think this seems to be a problem. So Judge Masipa and Judge Mosop, if you can please, also with the way that Mr. Ngasa was raising about starting and the uniformity between the two centers, I'll let you guys please deal with them. Mr. Mzulini, sorry, I'm just allowing my colleagues because we literally have 2 minutes. I'm not allowing the practitioners anymore. Colleagues, anything else you want to say? All right. Then, yes, Judge Hendricks?
JP, sorry, there's just one thing. I've seen further comments that practitioners have said they are experiencing difficulties implementing Rule 37.8. It has been brought to my attention, and I am having a meeting with the JCM clerks in Durban about it, and I will speak to Judge Sabia so that she can have a meeting with the JCM clerks in Maritzburg about it as well. Thank you.
Thank you. Mr. Mzuluni wanted to discuss something about agency, but I think I'm not allowing any more discussions. Unfortunately, the time is up. But agency, contact the chief registrar. The matter must be absolutely urgent. And as my colleagues have said, when you sign the certificate of agency, make sure that it is urgent. But I don't want to get into details. I just want to take the opportunity to thank everyone, particularly, firstly, the DJP and all my colleagues for the support, because I did ask them to attend so that we can all participate. It shows that I was not doing this on my own, but it is for the division. Thank you so much for your support and for making the time available. Thank you to all the colleagues, to all the legal practitioners who have attended. Thank you to Mr. Advocate Mlaba and your team, and Mrs. Mfusi and Mrs. Charita Govender, that made sure that we are here in this platform. If you want more of these, please ask the Legal Practice Council. This is just a start. Please, can we comply with everything that we have emphasized? We'll give it a month. After a month, we are not taking it anymore. Thank you so much, everyone. Advocate
Thank you,
Mlaba, are you
JP.
still there? Do you want to say anything?
Thank you, JP. Thank you very much for this informative session. But we want to assure you that we've heard you loud and clear. I'm calling upon all the practitioners to comply, because after this, really from what you've said and what you've heard from all the other judges, there's going to be enforcement of compliance. But really, people just need to read the rules of court, as well as the direct practice directives, and then be courteous. And some of the things that are being raised here about behavior in court and courtesy, it's just common sense. Maybe I suppose it's because we've done our pupillage and these things were emphasized. But these are things that we should not really be told about. But thank you very much, JP. But on our part as LPC, we are going to put this in our agenda and see what we can do to also educate our practitioners. Thank you, JP.
Thank you. Thank you, everyone. Have a good evening. Thank you so much. Goodbye.
Thank you, JP.
Thank you.
Goodbye. Bye.
Thank you.